Afternoon.
Good afternoon, Charity Kisotu, you are welcome.
Good afternoon, Honorable Commissioner.
Good afternoon, Omwanza Mbati, karibu.
Thank you.
Good afternoon, Your Honor. Anthony Mrima. I wish you the best.
Thank you, Honorable Commissioner.
Good afternoon, Mheshimiwa.
Good afternoon.
My name is Olwande Evelyn. You are welcome.
Thank you, Honorable Commissioner.
Yes, thank you. Thank you for that introduction, Mheshimiwa. If you could start by telling us your county and your ethnicity.
Thank you, Honorable Chair. I come from Homa Bay County. My ethnicity, I am Suba by origin, but majorly Luo.
Yes, and you work in Homa Bay.
Thank you, Chair. I work in Homa Bay.
Okay. You are not conflicted working for your people.
Thank you, Honorable Chair. I am not conflicted because where I was born, that is in Ndiwa sub-county, is 45 kilometers away from Homa Bay Township.
Okay, so you are not dealing with your kin.
No. Thank you.
Very well. We'll start the interview. We like our candidates to feel relaxed and make yourself comfortable. We want to get the best out of you.
Thank you.
The water in front of you is yours if you want to sip it. If you could begin by telling us your core competencies. What makes you think that you are distinguished, or what distinguishes you from among the almost 50 candidates we are interviewing, in terms of your skills, your knowledge, your experience, and how you can leverage that with the nature of the disputes that are before the Environment and Land Court. This is a very specialized court. Land is also very emotive. It requires somebody who is well balanced in law, emotional intelligence, and social outlook, socio-economic context. So we want to give you 5 minutes to package yourself as one who is distinguished to be nominated as a judge of the Environment and Land Court.
Thank you once more, Honorable Chair, for giving me this opportunity to tackle the issues that you put before me. I wish to inform the Honorable Commissioner that I am currently working as a Chief Magistrate at Homa Bay Law Courts. I was admitted as an advocate of the High Court of Kenya on the 7th of March, 1996, where I thereafter joined private practice. I practiced for 9 years before joining the bench on the 2nd of March, the year 2007. From 2nd of March, the year 2007 to date, I have worked as a judicial officer. That in total, I bring to you the knowledge of 30 years in terms of experience as a legal practitioner, that is post my admission as an advocate of the High Court of Kenya. Honorable Chair, in terms of knowledge, I wish to inform the Honorable Chair that as a judicial officer, my work is to hear and determine matters. For the last 19 years, Honorable Chair, in all the 8 court stations that I have worked in, I have been hearing and determining matters, inclusive of land and environment matters, in the nature of occupancy of land, in the nature of boundary disputes, in the nature of environment, being criminal in nature, like sand harvesting, along the lakeshores, operating, being in possession of the forest produce without a license, being found in possession of wild trophy or the wildlife trophy without a license. Honorable Chair, that now makes me to be competent to handle land and environment matters, and based on the 5 sample writings in terms of the judgments and the rulings, which are presented before you for consideration, some of which have been upheld by the appellate benches, I believe I have the skills to deal with land and environment matters, especially in the Land and Environment Court. Honorable Chair, for the last 19 years I have been a leader in the 8 court stations. I wish to inform that since the year 2015 to date, as a leader, I have exhibited strong leadership and coordination skills by empowering the team members I have worked with, by motivating them, and also encouraging them to be creative, purposely to assist the institution in achieving its mission, the goals, and the vision. Honorable Chair, just allow me to mention 1 or 2. In the year 2021, while at Kapsabet Law Courts, we operationalized Kapsabet Land and Environment Court. While in Vihiga Law Courts, we managed to acquire a title deed for the construction of a magistrate's court at Luanda Emuhaya, and this is purposely to help in bringing justice closer to the people. Honorable Chair, I'm also alive to the fact that a clean environment is key to service delivery, especially to the internal and the external stakeholders. While working at Vihiga Law Courts, I participated in the supervision and completion of a new court building, which has provided a clean and working environment, not only to our court staff, but even to the members of the public. Honorable Chair, in terms of enhancing access to justice, purposely by way of alternative dispute resolution mechanisms, this is one of the fundamental principles that the Land and Environment Court is called upon to uphold, purposely to encourage the disputants who appear before them to emulate before they come to court as a last resort. I am a trained mediator, and in all the court stations that I have worked in, I have promoted the use of ADR purposely to enable the parties resolve their matters out of court. Honorable Chair, you are aware that ICT is an enabler of justice as contained in the social transformation through access to justice. Since the financial year 2020-2021 to 2023-2024, I was a member of Administration of Justice Performance Management Committee that contributed to the implementation of performance management and measurement understanding. This tool has always inculcated the element of transparency and accountability, not only among the judicial staff, but the judicial officers and even the honorable judges. Through this tool, it helps.
I think now we are going to the technical area because we'll check your performance as well.
Thank you.
And I'll pass it on to Commissioner Mwanza to take it from there.
Thank you, Honorable Chair.
Thank you, CJ. Your Honor, there are several trusts that are applicable to the area of land. So the first one is constructive trust. If you can write, because I'm going to ask questions. The second one is a bare trust. The third is a resulting trust. And then the fourth is a customary trust. Perhaps if you can tell us briefly what each of those mean and the elements that apply.
I beg your pardon, Commissioner.
Yes.
The first one is?
The first one is constructive trust.
Thank you.
The second one is a bare trust. The third one is a resulting trust. And the fourth one is customary trust.
Thank you, Honorable Commissioner. Allow me to start with the constructive trusts.
Yes.
In terms of constructive trusts, this is where the interest or a person gains interest on a parcel of land by way of law. It is something which is derived from the law. In terms of a bare trust, this one, it is not contained anywhere, but it can be derived just from the conduct of the parties. On account of resulting trust, it can also arise by virtue of the conduct of the parties. That is the much I can say.
Okay, and a customary trust?
In terms of a customary trust, Honorable Commissioner, a customary trust is where the person must be related to a person who is in the registered owner of a piece of land. The relationship must be very, very close. It should not be remote. And in this case, the person who is alleged or claimed to be holding the land must be the registered owner of that land. Thank you, Honorable Commissioner.
Okay. Now, the second question is with respect to obligations in respect of the environment by the state under Article 69. Perhaps you can tell us 4 of them that the state has, 4 obligations that the state has under Article 69 with respect to the environment.
Thank you, Honorable Commissioner. One of the obligations is on the part of the state is to ensure that there is sustainable development in terms of the land that is being held by the state. Another one is on the issue of cooperation between the parties or the states when it comes to dealing with matters of environment. Another obligation of the state is to ensure that the environment is free from any pollution. And the fourth one, if I can say, is that in terms of the state is also under a duty to ensure that legislations are put in place for purposes of governing the activities that are taking place within the environment.
Thank you, CJ. That's all.
Thank you, Honorable Chief Justice, and Your Honor. Once again, welcome. Just 2 issues. One, under the Community Land Act, there are some rights which a landowner can grant to a third party. These are called grazing rights. In most cases, this applies in among the pastoral communities when you're dealing with community land. Now, these grazing rights can actually be registered against a title. They can be registered against a title. If that is to happen, how will they be registered? How will they be? Will they be overriding interest? Will they be leases? Will they be? How will they be registered against that title?
Thank you so much, Honorable Chair, for the question. In terms of the rights to be registered against the land, if these people have been in occupation of the land, then it will depend on how long they have been on occupation of the land. But if they have been in occupation, like in cases of leases, then that one should be registered against the land.
Maybe Your Honor, you may not have gotten me right. You have your land.
Thank you.
Your land is registered in your name or maybe in the name of a community. And then some pastoralists come to you, they seek your permission to graze their animals, and you allow them. It can even be formal. It can even be through an agreement. Now, these grazing rights can actually be registered. If they have to be registered against your title or the community land title, how will it be? Will it be a lease? Will it be an overriding interest? Because these are just grazing rights. You understand what grazing rights are?
Yes.
Yeah, just the permission to come into your land, graze your animals, and leave. So if those rights are to be registered, how will they be registered against the title?
Thank you, Honorable Commissioner. When it comes to being permitted to work on the land,
Yes.
there is a license.
Yes.
So a license need not be registered against the land.
Yes, they may not be registered, but if they have to be registered, how can that be done? How can that be done? Generally, they may not, but there are instances where parties, especially when you are dealing with community land, you may even go further to have an agreement reduced between the community and the third party, and that agreement may even be registered. So how can it be? Because if it's a license, you don't need to register a license.
Okay. Thank you so much.
Give it a try. I know you know it.
Thank you so much, Honorable Commissioner.
Yes.
When it comes to such like agreements, I know there is a committee that is supposed to sit down. It has to be reduced in writing, and once it has been reduced in writing, it has to be forwarded to the designated registrar of the community land. And I believe it is this designated registrar who has opened a designated register for the community land, who is supposed to have it registered in that register.
Okay. Now, in that case, these rights are registered as an easement.
Yes.
They can be registered as an easement. And lastly, is there a difference between legal ownership or legal interest and beneficial interest or beneficial ownership?
Thank you so much, Honorable Commissioner. There is a difference between legal and beneficial. In terms of legal, this is where land has to be registered in the name of a person. But in terms of beneficial, these are interests which are acquired by a person on account of the doctrine of equity.
Thank you. That's right. I wish you the very best. That's all, Honorable CJ.
Thank you, Chair. Good afternoon once again, Your Honor.
Good afternoon, Honorable
I can
Commissioner.
attest to the work that you did while at Kapsabet and Vihiga
Thank you.
in terms of building and bringing members of the CUC together, and your uptake of ADR. I've gone through your sample writings, Your Honor. You submitted decisions you have handled in various issues, commercial dispute, RTA, land matters, and they demonstrate your ability to clearly identify issues. You are able to make sound application of law to facts in a well-structured manner, and you support your decisions using relevant statute and precedent. They are coherent, well-reasoned, and well-grounded. Your tone is impartial and restrained, so I commend you for that.
Thank you, Honorable Commissioner.
In your introduction, I'll not ask you something with regards to environment and land, but something with regards to performance. You mentioned that you are in the committee that deals with judicial performance, and we have established that it majorly focuses on quantitative indicators such as case clearance and backlog reduction. There's been concerns that we also need to look at demands around delivering of substantive justice, the issue of quality, and that is number one. And then the other issue is the issue around measuring and awarding performance per court as opposed to per individual. So what is your thoughts around that now that you have had the experience of moving around the country and getting feedback? And lastly is the issue of the place of stakeholders in this particular performance management, because at times that stakeholders see people receiving awards and for lack of a better word, qua ground, things are different. Yeah.
Thank you, Honorable Commissioner, for the question. In terms of the concerns of the members of the public getting concerned where people are being awarded for the better performance, first and foremost, I would start by saying that at the moment, performance management and measurement understanding involves the internal stakeholders as the ones who are being measured in terms of the targets that they set on an annual basis. Again, when they are being concerned, the only issue that we need to improve on is training and awareness creation to enable them be in the know-how on what the judiciary is doing in terms of their mandate as well, to assist in the improvement and also the achievement of the targets that the courts are indeed setting, because without their involvement, no court can be in a position to achieve 100% on account of the targets that they sought. Like, for example, we have LSK, we have the ODPP, we even have the National Police and other members of the public. This way, if they are also robbed in, then they will also assist in improving the performance. They will also not be engaging in issues of the complaints. In terms of performance per court, yes, I can say that this is a very, very major milestone, but the only thing that I now commend the judiciary through the Administration of Justice Performance Management Committee and even through the Judiciary Training Committee that is the one which is involving the staff, we have realized that initially it was believed that target setting was just meant for the head of station. But it is no longer the case. Everybody needs to be brought on board, and through these trainings, PASS has also been incorporated as one of the tools to improve on performance management. Staff have also been trained to improve on the registry management, and that way I can say if we now incorporate each and every stakeholder in the performance management, not only the internal but also the external, that way we are going to move as a team. Thank you.
Thank you. And lastly, Your Honor, you're aware of 2 complaints that were filed against you. In one of the complaints, the petitioners, who are the complainants in the matter, filed a constitutional petition before the lower court, and the respondents filed a PO citing that the magistrate court lacks jurisdiction to grant the orders they were seeking. Some of those orders were declaration that certain rights were violated. You proceeded to strike out the matter based on that, and you gave your reasons. But their concern is that you proceeded to strike out the matter, and you did not transfer the matter to an appropriate court. We have seen your response, and we find it is satisfactory, because yes, we agree with you that you do not have powers to transfer a matter that is not properly before you. So we'll give a written response to the complainant with regards to that. And then the second one is a criminal matter where it's alleged that when the accused person failed to attend court, you were informed that he was unwell, but you still went ahead and demanded that he be brought to the court, and on his way, he passed on. Again, we've seen your response, but because of the nature of the complaint, we would also want you to shed more light on your response, because you have reviewed it.
Thank you, Honorable Commissioner. I wish to state that feedback is very, very key. It helps us to grow, and it also helps us to understand or to communicate with the stakeholders. Honorable Commissioner, I wish also to state that in a criminal matter, there are several other stakeholders, inclusive of the complainant, and when a matter is being handled in court, a quorum is always complete when we have the prosecution, we have the accused, we have also the judicial officer. In this particular case, Honorable Commissioner, this is a matter that commenced way back in June 2024, and the first time that I was informed of the indisposition of the accused person was on the 10th of March 2025, of which a date was given in the presence of the counsel for the accused together with the prosecution. On this particular day, there was a discharge note whereby it was indicating that this officer or the accused person was admitted in an hospital in Homa Bay. That is on 24th of March. Honorable Commissioner, I gave a date for mention on the 2nd of May 2025. On this particular day, the very letter which was brought to us on the 24th of March was the same letter or document which was availed before the court to confirm that the accused person is still in hospital but not in Homa Bay, but in a hospital in Kisii. Honorable Commissioner, the prosecution also noted the same concern, that this is the same document that was presented before us, so it would be prudent if the surety could just present before the court something to confirm that the accused person is admitted outside the jurisdiction of the court as he was presenting before the court. So based on that, we fixed the matter for mention on the 6th of May 2025. Again, I submit that the surety appeared before court, but on this day he confirmed that the accused person was being discharged from hospital. On account of humanity, on account of empathy, I gave a date for mention on 20th of May 2025 to enable the accused person not only to recuperate, but to appear in court if he shall have recuperated. But on the basis that if at all he did not, then a warrant would issue. Honorable Commissioner, I submit that by the time we mentioned the matter on 20th of May, that is when the surety in this matter brought a burial permit to the extent that the accused person passed on 6th of May 2025. Honorable Commissioner, there's no day that indeed I insisted that the accused person in this matter should appear while from hospital. From 10th of March 2025 up to 20th of May 2025, I exercised restraint. I was very empathetic. And even when I was informed that the suspect passed on, I was also empathetic with the family. Honorable Commissioner, I totally submit that to date I am empathetic with the family, but it was not intentional that the accused person appear before court while coming from the hospital. Thank you, Honorable.
Okay. So at no given time did you order the hospital to produce him?
No. Honorable Commissioner, I never ordered the hospital to have the accused person produced in hospital.
Okay, thank you, and I wish you the very best.